states. It says that the electors and Donald Trump sought the court's review of various rulings by the district court, and they affirmed some and they reversed some. Let me go to a couple that stood out to me. Section 3 encompasses the office of the presidency and someone who has taken an oath as president. On that point, the Colorado Supreme Court says that the district court committed reversible error. Another one, the district court did not err in concluding that the events at the U.S. Capitol on January 6, 2021 constituted an insurrection. The district court did not err in concluding that President Trump engaged in that insurrection through his personal actions, which we've been discussing. President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6, 2021 was not protected by the First Amendment. Those seem to be ripe issues for the Supreme Court to litigate. How do you perceive this going, given the fact that these folks, the majority, claim to be originalists? And the Section 3 was written specifically, originally, to stop insurrection and violate, and Trump apparently did so.
Well, first of all, thanks so much for having me tonight on the phone, Joy, and it's great to be here with Andrew. This is perhaps the most fun faculty meeting we've had in a while, and this is a great night for constitutional law professors.
Yes.
I'm salivating thinking about the new semester. The Colorado Supreme Court wrote a very meticulous opinion. This is over 200 pages. They went through every argument in incredible detail, explaining themselves with really remarkable clarity. And I think they did that knowing that this is on a bullet train to the Supreme Court. And as you say, they agreed with many of the district court's findings below, particularly insofar as Donald Trump engaged in insurrection. He recruited and incited these followers to go to the Capitol to engage in an act of insurrection, and his speech was not protected under the First Amendment. Those are incredibly important findings. Where they differ from the district court is in this question about the substantive meaning of Section 3 of the 14th Amendment. Again, Section 3 does not specifically mention that the president is one of the federal officers to whom it applies, but as you say, this was an amendment ratified in the wake of an American Civil War that was understood as an insurrection against the Union, and that any federal officer who had pledged to uphold the Constitution and then had joined the Confederacy was engaged in an act of insurrection, and that included everyone from the top of the ticket to the rank and file below. And so they came to the conclusion that the history, the text all supports the view that this applies to the President of the United States, even if the President of the United States is not specifically enumerated as a federal officer here. So this is going to the Supreme Court. As Andrew says, there are a number of jurisdictional avenues that the court can take to get out of this without deciding the substantive meaning of Section 3 of the 14th Amendment. I think one question here is whether or not the Colorado state courts even had jurisdiction to take this question up, and that will be something the court will attend to. The question of whether or not Section 3 of the 14th Amendment is self-executing or whether it requires some kind of congressional action, like a statute providing a cause of action, is also another issue that the court could decide this on. And then, of course, the due process issue, which Andrew just talked about. So there are a number of off-ramps here, but if the Supreme Court takes up this substantive question, determines that the text of Section 3 makes clear that it applies to Donald Trump and that Donald Trump was indeed engaged in an insurrection on January 6th, this is going to set off a domino effect that literally will go throughout this country as more and more states line up to decide whether or not they will disqualify. And remember, election law is a creature of state law. The states get to decide the procedures and the mechanisms for their own elections, even federal elections. And so each state can come to its own conclusion. So if the court decides this in a way that goes against Donald Trump, we may find ourselves with a patchwork of ballots on election night in November 2024.
And I will just remind